Okay, it's called to order the October 11th meeting of the Civil Service Merit Board. And I will start by calling roll. Jane Roberts.
Present.
Mark Dukes.
Present.
Stephanie Taylor.
Present.
Scott Schimmel is obviously not present today. I'm Bill Lyons and I am present. The first item is the approval of the minutes from the previous meeting held on September 13th.
Motion to approve.
Well, thank you.
Second.
Okay, we have a motion and a second. All those in favor indicate by saying aye.
Aye.
Opposed, no. Ayes have it, and minutes are approved. Okay, now it's time for the reports. Do we have any reports regarding litigation? George Shields, do you have any you'd like to make?
Nothing this month, Mr. Chairman. Thank you very much.
Thank you. Mr. Winchester, do you have any?
Nothing to report, Mr. Chairman, thank you.
Thank you. Okay, now we have the staff report, and we will call on Dr. Hatfield for that.
Sure. Updates on grievance activity. We actually don't have any pending grievances, that's good. I'm going to save the report on current functions to the end since it's sort of the longest part and I can breeze through the others. Report on current discrimination complaints or investigations. I have scheduled 2 interviews that are related on a related matter that could be a potential complaint, but they are not yet a formal complaint. So it will be a couple of weeks before the law department and I are able to conclude those interviews and make a determination on whether there is actually a formal complaint and investigation to go forward on those. We have completed the classified status updates in PeopleSoft. I'm going to say that we finally fixed what appeared to be broken, and hopefully that will be maintained going forward so that there's a clear record for every person and position of the classified and unclassified status relative to civil service. So there's just a one-stop shop that everybody can go to and find that information. I did, at the request of KPD, an accelerated advancement workshop last week, and the primary purpose was to answer questions on accelerated advancement. And for the board that may not know what that is, KPD and Civil Service developed a program many years back that if we hired in an officer with prior law enforcement experience, once that officer completed probation, that officer could apply for credit for a previous time at another agency. And KPD would do an evaluation and assess a certain amount of time to be credited that would be equivalent to KPD service. And that time then can be used to accelerate that employee through the promotional process. We really didn't use that program a lot because we didn't hire a lot of laterals, what we call lateral officer, because basically when someone came from another agency, they had to start over here as a recruit. They had to go all the way through the academy. And we didn't have many who wanted to do that. So it was not something that was extensively used. When Chief Thomas and I discussed bringing back the lateral entry program back in, I think, 2018, and did so, that created a lot more activity in the accelerated advancement realm. So at first, KPD requested that we stop doing accelerated advancement. We basically put in the rules that it did not apply if you were a lateral candidate. But we left it in there in case they changed their mind, which they did. So after hiring laterals for, I'm going to say about a year, KPD decided they did want to go ahead and offer those laterals the ability to use that accelerated advancement. So the number of applications for accelerated advancement is significantly more than it used to be. And so what has happened as we're getting this influx all of a sudden of applications that we had never had before, there were a lot of questions. I think a lot of the laterals were confused. They didn't necessarily understand the rules or the process. So I went over primarily to answer those questions and help all of them understand how it works, what they need to do, when they can do that. But what actually was an unanticipated byproduct of that workshop was that I had requested that the panel members who actually apply the experience, that review those applications and say this is how much experience you will be credited, that they be there as well. Because if the candidate had a question about that part of it, I can't answer that question. I can answer application and process on the front end questions, and then how that is used in the promotional process. So we were all there and ended up just having a really good, lengthy discussion about how the program could be better. And so some of those things are going to be on our side. So I've actually requested that we have a formal meeting between Civil Service and KPD to kind of look at some of these suggestions that came out of that workshop last week, see what we do want to implement, what we do want to change to make the program less confusing and more streamlined and work better. So some of those, depending on what we end up coming up with KPD, some of those could actually be brought before the board. They could end up being rule changes. So I just wanted you to kind of have a heads up that that's something that we're looking at, and I think we can make some good changes. It'll make that program work even better now that it's really being robustly used. It's time to kind of tighten it up a little bit. And also just want to let you guys know that I attended HR's supervisory training that they held. I think they do that quarterly, and it was a great diversity, equity, and inclusion workshop. And they talked some about the new e-performance tool that the city's going to start using. So that was a really nice training to go to. And at the risk of boring you all, there's a lot of high-level conversation about the EEO functions of the Civil Service Department, but I realize that a lot of you don't actually know on a practical level what do we do. So I thought that might be helpful information, and I'll try to go through that as briefly as I can, just to let you know what actually on boots on the ground in the department, what are we doing, and how does that operate in just a practical day-to-day sense. So what seems to be probably the biggest piece of it, even though it's not as frequent, it's one of the things that seems to be the most topic of conversation, is that we do take the complaints of discrimination, and we do those investigations. I took a look back just because it was really interesting. I was looking to see where did those rules come in, and in 1981, after the charter amendment, that put the EEO Title VII function with the Civil Service Merit Board, the administrative rules were silent on Title VII. There was no mention of it in the administrative rules. It only existed in the Civil Service Merit Board rules at that time. It was placed in the administrative rules in 1988, not until 1988, and at that time it directed that all complaints and investigations would go to Civil Service. So that's how it has always operated under the existing charter. In 2003, at the request of Civil Service, that rule was amended. So until 2003, reports only went to Civil Service. In 2003, then Director Karen Day asked that the law department be added to that complaint mechanism, because what if the complaint was against Civil Service? So that's the reason for that dual reporting structure. I don't feel like that is a confusing structure, because whoever those complaints go to, you're still going to have a dual report, just in case the complaint is against the primary party that would take the complaint. So you're always going to have an alternate that those can be reported to. So at that time, it was the law department. And so we do, when we receive those complaints, I can't think of one that has gone to the law department first, other than there was one in, I believe, 2004 that was against Civil Service. So that went to the law department. They always typically come to us first. I can't think of any that haven't. And I do confer with the law department. So when those come in, the way that process works, I receive the complaint, I contact the law department, and it's a joint process with me and an attorney from the law department. We review the initial complaint to see if it meets the criteria for a formal investigation. If it does, we do that investigation jointly. And I do think it's important to note that currently, and since 2020, the Civil Service report, it's simply a summary of facts. All that we serve as is a fact finder. We interview witnesses, review documents, report a summary of facts. There are no recommendations included in those reports. Prior to 2020, Those reports did include soft recommendations that would include training or opinions on rules, if a rule was brought into question. And the reason that included those things prior to 2020 is because before 2020, the administrative rules placed responsibility for training with civil service and responsibility for issuing opinions on the administrative rules. So it made sense that that was part of that report, but since 2020, those have not been included. There's been some mention of, the reporting structure is confusing, employees don't know who to report complaints to. So I wanted to just touch on that just a little bit to kind of tell you where some of those things lie. Prior to 2020, civil service was responsible for all training in the city. Up to that time, we did a 1-hour discrimination and harassment training that included how to report complaints. That 1-hour training was given to every single employee. We did it on their first day of employment, and when that program was implemented, we got permission from the mayor to catch everybody up. It was made mandatory for everybody who had not had it when they were hired. And we tracked that in a training database, and when we stopped administering training, 100% of city employees had had that training. So I don't think there was confusion about how to report a complaint because 100% of our employees had received that training. Since that time, I don't know what the training is and I don't know what's communicated, but I do know that at new hire orientation, there's a graphic that's provided to employees and it's a quick reference chart that shows which department to go to for certain things. Do you go to civil service? Do you go to HR? Do you go to benefits? Because it can be confusing. So a chart was made, and I became aware of that in January of this year. And under both the civil service column and the HR column, it says, report complaints of discrimination and harassment. And at that time that I became aware of it, I did contact the HR department and said that appeared very confusing and actually requested that that be amended. And in the most recent copy of that I received at the end of August, it had not been changed. So there may be some confusion. I would think that something like that would generate some confusion. But historically, I don't think that has been a confusing structure or a confusing way to know how to report a complaint. That hasn't been my experience since I've been doing it. And in addition to discrimination and harassment complaints, which seems to be the big one, and I say it's the big one because it's sort of the one that people are interested in the most. But just so you know, I went back the 20 years that I've been doing them, and we receive 1 to 2 a year. So this is not something that there's a tremendous volume of. We receive and investigate 1, maybe 2 complaints every year, and that's consistent. The other things that we do that are not part of that investigation process, we do provide the enforcement of EEO policies through our recruiting and hiring. Obviously, how you recruit employees, hire employees, that's a big piece of that. So that's how, in your rules and how we operate, that's how that is carried out and enforced for hiring matters and testing and applicants and getting accommodations. All of those things are wrapped up in our rules, and that's how we carry that out. We also have, you may or may not be fully aware, we have a rule that the board has passed called extended certification, and that's something where I do an analysis when we receive requests for applicants to be forwarded to a department. Typically, it's the top 5, but in our rules, I can go in and any time there is a job class or a department that's underrepresented, I can authorize expanded certification so that it expands that referral to include more applicants to capture more minority applicants for consideration. So that's another process that's housed in civil service.
But they're still ranked, right?
They're still ranked, yes, and all the rules still apply. It simply expands that list down farther. And then all the rules that would normally apply still apply. And that's been there, I don't know, since I've been here, we've had that rule. We typically provide the diversity metrics for various departments. When asked, they usually get those from us on applicants and employees. I have been a member of the Mayor's Internal Equity and Diversity Committee since it was started back in 2015. And we prepare and submit the annual EEO4 report to the EEOC that is done every 2 years, and we provide KPD's EEOP report as well. We also, the other thing that we do is I provide the Title VII statistics to the Title VI coordinator every year for inclusion in their annual report. So that's just to let you know what our actual activities are. So when we're talking about these Title VII functions, you know what we actually do. That's it.
Okay, thank you, appreciate that. HR.
Good afternoon, everyone. Hope everybody's doing well. I'm going to give you a couple reports, and I'm going to move out of order a little bit, and then I'm going to give you some additional information. On my report, I wanted to talk about the recently attending the HR conference and program updates. I'm going to give you a little bit of things. This past week, 3 of us attended from the HR department the National Public Sector Human Resource Association Conference. It is a national conference on best practices in public sector. I was asked to speak nationally on leadership in HR, and I was blessed to do so. Prior to that, I was asked to do a national webinar on managing and leading change in the HR in the public sector space. So it's been a great opportunity of these last few months, and I just wanted to share that opportunity and let you all know about that as well. Partially in my report, I wanted to let you know about the updates HR changes going before City Council, and those things are going to be presented to City Council on November 14th. Every year, we do twice a year, beginning of the year and the second half of the year, to look at things, and it will look at retitle, new titles, and reallocations. We have, let me read this to you. We have received 14 requests to create new classifications and 1 reclassifications. Reclassifications will not go before the City Council. The HR Review Committee is scheduled to meet on 10/18 to review and go over those positions. Once we do that, we will present and we will send that information to Civil Service as we always do. And so in the past, we've had multiple people on the HR committee from various departments. This year, Christine Stickler has decided to step down, and Brooke Wright from KPD has been asked to join the committee. So we're looking to bring information. We will bring this to Dr. Hatfield in late October before we bring this before the November 14th City Council. The other thing that I wanted to report to you is that we had to do an HR audit. Where did I put that information? And I wanted to get that information to you as well. HR was responsible for an audit. On Friday, October 6th, Cindy Rimpert with Pew CPA conducted an I-9 audit as part of the pension auditing testing system. We were requested to pull 70 I-9s and discuss the onboarding procedure for all new employees. So Cindy was pleased with the results and did not have any reports or findings. So what we say to that is we look at our onboarding process and communication and the things that we're doing a pretty good job there. So I think I want to have that conversation with you all, and then I want to take a moment to leave you with this next piece, and it's just talking about the EEO. I've asked Devin Lyons to come back if you all have additional questions, but today I hope we don't get there. So let me start by telling you a story. 33 years ago, in March of 1990, I walked into 464 as the HR technician working for the Civil Service Department. Many of you all may not know that. If you walk into our office on that day, when you walk into that office, I was the first person you greeted. I was the HR technician. I made $16,000 a year, and I answered the phones. And it was my first job out of college. Karen Chancey, who she mentioned, was the person that hired me and told me that if I didn't take the job, I would never work in the city again. So that was her statement to me at that time. My claim to fame, and I still stand by this claim to fame, with $16,000 a year, college graduate, My claim to fame was that I created the first job line for the city of Knoxville. I created the job line, and where our refrigerator is now is where the job line used to be. And so what I'm saying to you, that claim to fame in 1990 and what I did in 1990, by the way, the job line was a tape recorder. But my claim to fame then was something that I'm still proud of. But if the city of Knoxville was still using that job line today, it would not be the right thing to do. I'm going to tell you a 33-year story. No, I'm not going to take an hour and a half because we don't need to be here for that. But my first beginnings was at civil service. My first beginning, when we talked about all those names, all of those people, I worked for Mintha Roach. She helped me to get my start in the HR field. My start came here at the city. The reason that I was able to come back 30 years, now 33 years later, and walk in the same door and now head the HR department from where I started is because of my love and respect for service. And it comes from my ability to love what I do. So I'm not coming in here and saying, okay, I'm the angry black woman. I'm not coming in here saying I got the most education. I'm not coming in here saying that this is the best practice and not go here. I'm coming here from that civil service employee 33 years ago, and I'm walking to you today to say, if we were still doing a job line, the way we did it then, it's not the right way to do it. Nothing wrong with it, because I think it still would work because I started it. But nothing wrong with that. But what I am telling you is that I hope we don't spend our time today taking the time looking and going back and saying, love, and is this the charter, is this right? I think when we look at this, there are legal precedents that we can look and we can go and we could argue for years. I don't think that's where any of us want to be, and I know it's not in the best interest of employees. What I know to be true is that as years change, as times change, Vicki talked about a thing in 1988 that was done, and then in 2020 some changes that were made, and I agree, changes are made because it's better. The way that it was done in one place and the way you did it then you said, okay, wait a minute, we had to make a change. So in 1990, we made another change. What I'm coming to you today is saying it's time for another change. What I'm coming for you is telling you, walking in here, I don't even want to talk about best practices, even though my level of expertise can prove to you that it's best practices. We've had documents to talk about best practices. I want to talk about efficiencies and how do we work on the best interests of our employees. Even though we've done it this way, even though I've heard this report for the first time, even though I've heard that, even though I know that I could disagree with some of those things, that's not even the point of this. Because there's no point to go and to pick, you said this and I said this, and this is what was done and this is what we did. How ineffective is that? How inefficient is that? When we look at what do we need to do to move forward, the things that we did when I started in March 1990 are not the best practices today. It's not the most efficient way to work on behalf of employees. I just spent a week at a conference learning about AI and artificial intelligence in going places and how do you use that. And as I teach, when do you use this on a collegiate level? And I'm sure Dr. Lyon can talk a lot about that from over at UT. How do you use that? And we're arguing back and forth, what's there? 5 years ago, we weren't talking about AI, but today we're talking about it. 5 years from now, we're going to be having other discussions. And what was done, what was put in the administrative rules in 1988, 1990, 2002, 2003 was done because civil service was in charge of that piece of dealing with HR or personnel at that time and dealing with civil service. We now have a different system. We don't have the need for civil service and HR. It's no longer together. I was not here when that was done. I had nothing to do with that. But what I'm telling you is that what was done in 2020 before I came was to have a two-part system. And as you look at this efficiently, as you look at where we're going, let's not argue about charter. We can do this for years. I want you to think about interests of employees, efficiencies of employees. What was done in 1989 when it all was separated? Okay. When it all came together, excuse me. Okay. But as we look at this, 33 years ago, I came in making $16,000 a year. And I came in answering the phones. And I came in civil service. In 33 years, I've got a lot more experience. I've got a lot more know-how. I've got a lot more expertise. And because of those things, I don't do the same things that I did in 1989 and 1990. So as I talk to you all today, as I end this conversation, as we move forward, I implore you as a board, as we work together, as I have been able to come up here and give you information about what HR is doing, we have different roles. There is no, I am going to say this for everybody in this room, everybody's watching. I will stand 100% and say we should never take the civil service away from our employees. It's needed, it's required. What I'm saying to you, that there's things that as they looked at what was done in 1989 and 1990 and in 2000, that when they were together are no longer together. The city council made the decision, the city council made the recommendation. I was not here to separate the two, but I am here now saying that as we look at this, as we've separated the two, let's think about the efficiency and the effectiveness for all our employees. Thank you. Well,
Will's a passionate speech, you got it. I've been rude.
Okay, well, thank you. Let us, now, do we have any unfinished business? I don't appear that we do. Does not appear that we do. We have some new business. Let's proceed to item 5, request by Police Chief Paul Noel to exempt from civil service one grant-funded position of firearms examiner trainee until June 30th, 2025. We have an attachment from which is the KPD exemption requests. All had a chance to look at this. Do we need any further information from anybody?
I think these are just more exemptions, similar to the ones that you did last time,
Right.
based on the same grants.
Is it the same grant? Is that what it was?
Yeah, it looked very,
It's all
it
rolled
was
into
very
one ball.
familiar.
Yeah.
Okay,
Motion to approve?
thank you, Mark.
Second.
We have a motion and a second. All those in favor of item 5 indicate by saying aye.
Aye.
Any opposed? Okay, item 5 is approved. Item 6 is a request by Police Chief Paul Noel to exempt from civil service one grant funded position of evidence custodian until June 30th, 2025. Likewise, you have the attachment and the exemption request. Does anybody need any more info or want to hear any on this? Are we ready to proceed?
Motion to approve?
Thank you.
Second.
A motion and a second. All those in favor indicate by saying aye.
Aye.
Okay, item 6 is approved. Thank you. And item 7 is a request by Police Chief Paul Noel to exempt from civil service one grant funded position of audio video technician until June 30th, 2025. And again, you have the attachment and the request. Similar situation.
Motion.
Second.
We have a motion and a second. All those in favor of item 7, please indicate by saying aye.
Aye.
Opposed, none. The ayes have it. Okay, now we have item 8, and we have two people signed up to speak. Of course, this is a report that does not have a proposed voting item, but it's a continuation of the report from last time. So if it's okay with the board, we can have our required speakers then speak at this time. I think would be good. We have Larry McAfee from the fire department.
He's in Zoom, he's on by Zoom, hopefully he will unmute.
There it is.
Okay.
He's on.
Okay, Larry, you've got, I believe, 5 minutes? Yeah.
Yes, can you hear me?
Yes. So we're ready to hear from you.
Okay. Well, thanks a lot for letting me go right behind Dr. Drummond. That's a tough act to follow. But I'll be very transparent and honest with everybody. I spoke with both parties. I spoke with Dr. Drummond. I spoke with Dr. Hackett, just to get some clarity and see where each party stands. On the surface, this seems like a simple issue, you know. These responsibilities and duties should be with HR, and these responsibilities and duties should be with civil service. But when you dig a little bit deeper, and I know Dr. Drummond is probably not going to like this, and we talked about the charter, there are some protections that the civil service has, and I'm happy to hear Dr. Drummond say that civil service has a place and it's not going anywhere. Because that's the main concern of firefighters is we need our civil service protection. But my concerns isn't with Dr. Drummond or Ms. Hatfield because I feel like they would do what's best for city employees. With that being said, if you look at Article 10 in the charter, there's 10 section 03, section F, number 11. It says civil service should develop a program to provide EEO to city employees. But what it doesn't say is that civil service should be involved in enforcing or investigating EEO complaints. Maybe I missed that in another section, but I don't see that in there. Maybe one of the attorneys can handle that for me because I'm not an attorney, I'm not going to pretend to be one. And I'd like to reiterate what Dr. Drummond said as far as the charter stating responsibilities and duties to civil service. Well, we didn't have a personnel or an HR department at those times, so therefore those duties, rightfully so, fell with the civil service. So, with that being said, the firefighters are in favor of civil service handling discrimination issues based on hiring, promotions, terminations, and demotion. Harassment aspect of this goes to HR. Thank you.
Okay. Thank you. Okay. We now have also requested to speak from Jason Hooker from the police department. Thank you.
This is my first time speaking in front of you guys. It's okay where Dr. Drummond was at, right? I'd like to thank the board for the opportunity to briefly speak on this matter. I've been employed by the City of Knoxville Police Department for 25 years. I'm currently assigned to the Criminal Investigation Bureau as a detective. As the KPD employee representative, my duties include working as a spokesman for the members of KPD and the go-between with the Chief's Office, the Mayor's Administration, and other city bodies. I've read the executive summary on EEO program prepared by Mr. Line. Based on this summary, personal knowledge, I feel the need exists to streamline the process bringing discrimination complaints to a single city body. Personally, I think having Human Resources act as a one-stop destination for all discrimination complaints is a good idea. The move will not take away any civil service protections from eligible city employees, and the Civil Service Merit Board will still act as a body hearing appeals from disciplinary actions. I've spoken with a number of KPD employees about the issues discussed in Mr. Line's summary. Nearly all the feedback has been positive in nature, with consensus being the present system can be seen as confusing as to who we speak to when and where to take complaints of discriminations. Not all the feedback has been in favor of the proposed change, but the vast majority has. It was brought to my attention that the Human Resources Department may be too closely related to the KPD Chief's Office, and that Civil Service Office may be able to view complaints against KPD administration in a more non-biased light. In closing, I'd like to thank the board for the work it's done, and again, thank you for this time. Thanks.
Thank you. Okay, I guess now we can move on to Mr. Winchester's continuation of the oral.
Thank you, Mr. Chairman. First of all, I want to say something about Dr. Drummond's statements. And also the timing of her tenure here. I started as the board's attorney in March of 1990. Is that when you said you started?
Absolutely.
So we both have grown up with a lot of things that have gone on here and seen what's going on. And those names in Devin Lyons' report are not just names, they're people I know and knew. And they meant something to me and I respected them. And quite frankly, we think we're going through some bad times now, or some difficult times, or some changes. In the 80s and 90s, as you can tell from, if you've taken the time to go through and read this report, which has a tremendous amount of information in it. Most of it's newspaper reports and hearsay and all that, but it's been put together in a way that shows a time continuum. And what I want to do today, I'm going to do this as quickly as I can too. I'm not giving an opinion. What I'm doing is giving you a report on what I found in here, what it says, what its impacts are, where you need to focus if you haven't focused. And then I'm going to address the elephant in the room, if that's an appropriate statement. It's not Alabama. It's that we have a charter that we have to deal with. And it's not just a matter of what someone thinks ought to happen over here or who ought to be reviewing it. The law that we have to deal with, the touchstone that controls all this, is in the charter. It's not my charter, it's everybody's charter. So what I'm going to talk about today, and what I'm going to do is go through this and review these materials. The page numbers, if you hear me, and this is important because it's potentially confusing, those of you who are going to keep up with what I say today, or you can go back and look in the minutes or whatever. When I refer to a page number in Mr. Lyons' report, it will not be the package page number assigned to it for purposes of the City Council's workshop. It will actually be the page number of his report, because that could be very confusing if you're trying to say, well, I don't find that on page 8. So unless that's confusing for someone, I'm going to go forward on that basis. The materials and background are extensive in their scope, and the scope is not just limited. And for those of you who were not on this board when this process started that resulted in this report, I'm going to take just a couple of minutes, unless somebody says, don't go there now or you don't want to hear it now. Let me tell you a little bit, because I think the context is important on where we've been and what we've ended up talking about now. The reports that were generated by Civil Service, the Mayor's Office, were in response to City Council's resolution that came forward in July, on July 27th of 21. Council Member Parker initiated a resolution that actually saw a zero tolerance. It was substituted later by Councilmember Fugit to the resolution we have now that asks the Mayor's Office to get with, and I think it's important to read it because the cooperation and efforts that Dr. Drummond, I think, is implicit in what she just talked about, and what I've talked about several times, was set forth in this resolution, and I'm reading from the resolution. It's R-263, 2021, and what started this discussion was a resolution where the council respectfully requested the mayor and her staff work with the law department, the human resources director, the director of civil service, and the Civil Service Merit Board to study and make a report to City Council within 120 days regarding the city's existing policies for racist and sexist practices within city government. That was the scope, as well as any recommendations to strengthen this policy as permitted under the city's civil service rules and applicable law. Now that's where we started. Many of you know that. I'm not going to, unless requested, and please don't request it, because I don't want to read from all these reports. But what I'm going to do is address what the reports, where we ended up, because the massive amount of information in this EEO report and the detail, I agree with Dr. Drummond. We're not here, and I'm not here today, to argue about every point in there. There are some points in there that need to be clarified because this board sits as basically a non-paid citizen board. You have duties and responsibilities under the charter, and you've been told, or there has been a narrative created, that somehow you don't have the power to enforce some of the duties and responsibilities that you have. I have to address that as your lawyer because I believe that there are things about that need discussion and need clarification. Also, I'm going to discuss some case law because there is no case law, and the case law that has occurred, I'm going to talk about toward the end because I'm going to give you some background and go through this, because without that, I don't think this will make as much sense to you. Not because you don't know what you're doing. We have professionals, educated people here, and experienced people here, and people who have dealt with employment matters. And no one, Dr. Hatfield says EEO functions, they know what that means. Most people do not. And as I go through this, the thing that has impressed me the most about the detail in here, in the report, and when I say the EEO report, I'm talking about this report from Devin Line. A lot of the information between 1945 and 1986 in the historical record, it revolves around and ends up going through the, I guess you'll call it the filter of the 1981 charter revisions, and the charter that was not adopted by just city council, or it was approved by the voters of this city. This is what they said they wanted and what they approved. That law is still on the books. Those provisions, with one or two changes I'm going to mention, has stayed the same for Article 10 as it was in the 1980s. To be sure that I don't waste your time, I'm going to not consider the matters that were brought up, except to the extent that they became or have been expanded by the EEO report that's now in front of us. The most important references that I'm going to reference is Article 10 of the Charter. And I hope, and I brought a bunch of extra copies, because if you don't have this charter in front of you, you're going to be lost as I go through this. Hopefully, does anybody need a copy of the charter? If you do, there it is. Okay? Let me throw it at you. I've got one for everybody. I didn't bring it up for everybody in attendance, but I did bring it for everybody on the board, I think. The most important takeaway, if there's going to be one that you take from my statements today, is the EEO functions described in the report that were part of and referenced primarily in section 1003F, powers and duties. The powers and duties of the Civil Service Merit Board shall be as follows. Shall being the key word. This is what y'all are responsible to do, to take care of. those powers are also amplified by another section of the charter that, in the wisdom of the drafters and the voters, Section 231. And what 231 says is, and I'm reading the part that is relevant for these powers. 231 of our charter says, when any power is vested by this charter in any specific officer, board, commission, board, that would be you, or any other agency, the same shall be deemed to have exclusive jurisdiction within that particular field. Not my language, it's the charter language. So in other words, those specific duties and powers that you have in F and elsewhere in Article 10 that I'll be mentioning from time to time, you have exclusive jurisdiction within that particular field unless the charter says otherwise. Not city council, not the mayor, not even this board. It's what the charter says. Exclusive jurisdiction is going to become important when we talk about some of the cases that have come up following all of this, the issues that generated in the 80s. This isn't the first time there has been a potential shift, change, or challenge to your powers. There's case law that I'm going to mention that we'll talk about, and I think it'll be relevant. The charter provisions govern who and what function and authority control substantially all recommendations made in the EEO report. And when I say the EEO report recommendations, just for again those of you that want to keep up with this, the recommendations that I'm looking at, I always read these reports backwards, by the way, just like I read the cases. You want to see who won or lost first, and then you go back. It makes more sense as you're reading it to see how they got there. The recommendations from this report begin on page 53 of the report, and they go through, well, basically the end, but there's the conclusion on page 63 that I'll get to next. And those are the things that I want you to understand first, because what has happened is, since the city council resolution has come along that laid the groundwork for this report, if you read, which I've already done, section 1 of the resolution, and then look at the civil service report, my report, or the civil services report of November 10 of 21, there were recommendations made on page 20. The mayor's report followed shortly after that, November 30 of 21, and it made recommendations. And the reason I'm bringing that up is because the mayor's report, if you have read it or you take time to read it, and again, that's something that you have to decide whether you want to do. It made recommendations and took a position that is somewhat different than what's in the EEO report I'm about to go through. Specifically, if you read the mayor's report, and the mayor's report on page 6 and on page 7 talk about the powers of the Civil Service Merit Board. Civil Service Merit Board having the power to hear allegations on matters of discrimination, the powers and duties of developing a program to provide for equal employment opportunities to all employees and applicants in regards to all aspects of employment. Let's be clear on one thing here. What we're talking about here are the Civil Service Merit Board has been given jurisdiction in matters involving employment that are exclusive to this board. Exclusive to this board. And quite frankly, it's a little bit, I guess, strange when I read through some of the history that this board doesn't have certain powers if you to do things. If you look at not just 1003F of the charter and of your powers, if you look at G, the Civil Service Merit Board, 1003G, after public hearing, the board shall specify rules as to the conduct of certain things, including investigations, hearings, procedures, and such other matters as are necessary for the execution of its powers and duties. In other words, this board has always had the ability to promulgate rules, regulations, and procedures to enforce its powers. Always. And you've done that. The mayor's report recognizes that. Look, Article 17 of this board's rules. The same language in the charter that gave this board power to adopt rules, regulations, and procedures to enforce your duties is similar language in the charter under sections 303, where the mayor's directors are given the power to prescribe rules and regulations, not inconsistent with the charter, for the regulation of their departments. That's always been part of this charter. So, if one of the narratives from the report that I have noticed that is probably the most important takeaway that you should have today is this. We need to look closer and analyze and look at and say, okay, what exactly is the city being advised, or what the recommendations are in this report, and are they consistent with the charter? Because if they're not valid. If they're inconsistent with the charter, they're not authorized. There is no charter authority for the mayor to develop a program for equal employment opportunities. It's not jointly. It's not stated jointly. It's your power. Yes, ma'am.
I was going to ask, I hear everything that we're going through. Is it necessary that we continue to repeat what we went over last time? Or
No.
do we?
No, I'm just giving you that background.
Do we need to? Go ahead.
I'll have my moment for questions once we wrap up with some of the other presentations too. And I know, Mike, you had summed it up. I believe I had the same question at the last meeting.
Okay.
With the board having the power to create the EEO, develop plans, we'll go to section F here. So I want to, under 11, develop a program to provide equal employment opportunities to all employees and applicants for employment with regards to all aspects of employment.
Yes.
So that is something that we all can decide today, if necessary, moving as a board, and take a vote on what we can do moving forward as far as delegating portions of the process for EEO. I understand the hiring, promotion, transfer, and then the harassment and discrimination. So we collectively as a board have the authority to put a motion forward to begin working on that, basically a separation.
Not exactly. If you're going to do a rule, we have to publish it. Okay, we have to follow the requirements of 1003G that says how the rules are adopted. You cannot waive or delegate powers and duties given to you by the charter to anybody else. You can determine by rule or procedure or regulation how those matters are to be enforced and how to go about doing it. One of the basic problems that I see that generated from the historical information is that it was more of a staffing, who had employees. The Civil Service Merit Board only had this board and one staff member. That was the executive secretary when all this started out. But and there was a big clash between administrations on, well, who was going to have the EEO functions? And there was this clash among the law director and even Charles Sturkey, who at one time was one of the Civil Service Merit Board lawyers, I believe, or was on, they were two individuals who had a lot to do and were very involved in the drafting of the charter. And because of that, I think that one of the things that started, and this is on pages 42, 44 of the report, and this is important because your predecessors on this board were asking questions about, wait a minute, and I'm reading from the 1983 minutes because this is important for now. They were saying, you mean we have duties and responsibilities, but we don't have any way to enforce some of them? Now, not all of them. They're not talking about all of them. They're talking about some of the EEO functions primarily, but not all of them, because there are some things listed in 1003F that only you can do. And I believe that if you read section 10 of 1003F, about taking further action as it may determine that you have, plus 1003G, you can pass these rules and regulations as you determine to enforce all of these powers that you have. But to get back to the report, the Irma Greenwood, for instance, who sat on the board, asked questions as you might think any board member would, to say, and I'm looking at page 42 now, she asked if the board had a duty to administer the EEO functions. Mr. Sturkey, who was the attorney, advised that the board has a responsibility to do that. But the charter does not state how it is to be carried out. At that time, it may not have, because rules and regulations, I cannot tell from the historical context or from just this report what all rules and regulations were in place at that time. I haven't been tasked to do that. I've been tasked to look at this report. All the board members indicated that they would still fulfill their EEO responsibilities, but that they would not, and they would not seek to have a position of an EEO administrator due to the lack of funds. Actually, what happened at that time period, based on my reading of the report, is the administration said that I'm giving enough, we can talk about having money for an EEO administrator, or we can pay for a lawyer. Which one do you want? They got a lawyer. But they went forward with their duties and responsibilities. And quite frankly, I think in my review of what I have seen in the report, the reason we have code sections 15, 53, etc. on enforcement officers is because there was if not a compromise, I think actually, when you look at the report, the city council said, I think we need to have the Civil Service Merit Board, a staff member involved. And John Roach, who was the law director at the time, said, I think an ordinance will fill that gap. You have to remember, if during this period of time, the city didn't wasn't running the personnel system, didn't really have an HR department. They had pretty much said, civil service, y'all do this. Now, So here you have civil service acting to some extent by default to run the personnel system and the civil service, and there was overlap. And there was the executive secretary doing things. The executive secretary has authority under the charter, under 1003C and D, to serve this board and provide assistance as the board may require. If this board passes a rule, reg, article, and says, we want our executive secretary to do something, which you've done, like in Article 17 on investigations, she has that power. She has that authority. Because that's what the charter says you can do, and that's what happened. Now, all the confusion that we just talked about earlier too, that's cited on page 58 of the report, and if you look at page 58, this is the key point of this report, in my opinion. I will give you that, my opinion of reading this report. The key point of where we've ended up is not just addressing sexual harassment or how we could improve certain parts of EEO functions. This report recommends what I call a sea change. It basically says, and if you look at page 58, and I'm going to read from page 58. It says this. This is because, one, positions with EEO-focused duties, we can go back to that again if we need to, focused duties, I'm not sure exactly what EEO-focused means, should be reorganized so that they are located within the HR department. So we're not talking about just the HR department in the mayor's office and this office making recommendations anymore. This recommendation is they be reorganized so that they are located within the HR department. And two, the scope of the HR department's duties is broader than the scope of duties to be performed by the Civil Service Merit Board. Organizationally, I'm still quoting, city processes can be streamlined and simplified by routing all EEO and employment-related matters to the HR department for resolution. Any matters that are being routed to civil service right now are going to be routed to the HR department? Is that what that means? I don't know for sure.
I want to stop a second here because I think we're getting somewhat redundant from last meeting as well.
Okay.
I will give a little context. This is I see it.
All right.
See how the board responds. This is a report, so there's no actionable item. I mean, eventually it could lead, my understanding is, to a proposed ordinance to implement some of these that would go before council. Is that correct?
If they are supported by the charter.
Well, of course. So I say let's just stipulate that the charter is our constitution. We don't, we obviously defer to the charter. However, part of that charter is the interpretation of the charter is done by the city law director and as the final interpreter of the charter. Is that not correct?
For city purposes, but the final arbiter of charter provisions would be the courts.
Well, I realize that, but in terms of if this goes to council and there's a question, this is where there is a series of issues that come up before that I've been concerned with, is that, when we're arguing, it's not up to us to make it, I'm not qualified to make a judgment about the meaning of the charter. And people are going to have different opinions. Of course, we've heard your opinion, which I respect. But also, there is a question of it being in the charter who the decider of the meaning of the charter, which is the law director, and the only way it gets into the courts is if it goes down another avenue. I'm not saying anything other than I just want to put that out there as context right now, because we're in a position as if we were in a court making a judgment on what the charter means. And that doesn't seem to be right now consistent with our role, especially because we don't really have any actionable item yet. We have a report that could lead the administration to propose an ordinance change to council, at which there might be then joined the questions you're speaking about, you know, which then in the wisdom of council, they could take into account. So I'm just saying it, I'm not saying who's right, wrong, otherwise, but that seems to be the greater context. So I guess where we are right now is, you know, we're responding to we're still responding to a report. And I don't know how much more we should spend our time before there is something actionable that would stem from the report. I don't know, I'll just throw that out there to my colleagues on the board.
I agree with, you know, it's a report, and right now, we're listening, and it's almost like what you're reporting from what the last time we were, and you giving your view on what we've heard, so to continue to, with it, what do you guys, I mean, we need to continue the report?
I very much am ready to give my closing speech.
May I just finish this one statement, because I feel
Yes.
obligated as your lawyer to make sure, because I did not go over this.
Mine is, I think we did ask Mr. Winchester last time to give us an analysis this time.
Well,
I think that's.
let me finish that quote and then I'll move on. Because this is the part that I think you need to understand, regardless of where we go from here with this. Okay, and I respectfully would ask that I be able to finish this. But okay, I've already read that part about would be routed to the HR department. This is the key part. From there, should a matter invoke the Civil Service Merit Board's jurisdiction pursuant to city charter, the HR department will be obligated by code to notify the Civil Service Merit Board. That means that someone in HR is going to be looking at matters that normally you would make your own decision whether you had jurisdiction. Someone unnamed, whether they're trained in the matters that you deal with or not, someone else in another department of the city will be looking at matters and deciding whether the matter invokes your jurisdiction. I think that is something that is inconsistent with charter provisions and basically creates an opportunity for you not to know about jurisdictional matters firsthand until someone else in a different department. I don't think that you should go forward with reviewing matters without knowing that that's one of the main points of this report.
Appreciate that.
All right.
Okay, so
Do you want to hear any more of this or not?
I think does the board, who would like, we have the city, we have George Shields in the city law department. We also have Devin Lyon who prepared the report. Would any board members like to hear from either, or George, did you have something you would like to say? We can't hear you.
George?
Hey,
George.
No, I'm not.
Okay.
Can you hear me now, Mr. Chairman?
Yes.
Okay, I wanted to clarify, as it stands today, there are already reports of harassment and discrimination that may be reviewed by someone other than the Civil Service Office first. I myself have received complaints of harassment and discrimination as part of the law department's duty that Dr. Hatfield described a little while ago to also receive these complaints. It's not an exclusive jurisdiction. Today, it's a shared jurisdiction, and sometimes those complaints do come to the law department first. I'm particularly remembering one in 2020, and those complaints came to me. I reviewed what they said, and I advised Dr. Hatfield that some of the content of those complaints implicated our joint jurisdiction. As I understand Mr. Lyons' report, he's proposing the same structure that exists today, where that same process may, from time to time, play itself out. It may come in through one door and need to be referred to another door. And certainly throughout my tenure at the city, that has already been the case, and I suspect it has been the case for far longer than I've been a city employee. So I wanted to clarify that for the board's benefit, and pending any questions you all may have, that's all I plan to speak to.
Thank you. Thank you. Would anybody on the board like to hear either more from Mr. Shields or from Mr. Lyon?
I'd just like to say thank you to Ms. Lyons for the report, Winchester, that you did.
I'm sorry, I didn't.
Thank you for your information that you provided us.
Right, and we did request that, and we appreciate, I think, all of this. Just one, I want to give some overall context where I think where we are and what is before us, and we're anxiously awaiting your closing statement.
All right. Friends, Romans, countrymen, near and ears. Try to make some things a little more exciting.
I'm not gonna applaud.
Okay, I just want to say, and I know I don't want to belabor here too much, but I do want to offer my opinion for what it is worth as a board member here at the Civil Service Merit Board. And my background, I am a professional in human resources, like Dr. Drummond. I have immense respect for her and Dr. Hatfield here too. And I serve on the Tennessee Valley Human Resource Association Board of Directors. I have since 2018. I'm considered a thought leader locally in this space, and I am always trying to do my best to make sure that I'm up to par on best practices, and my clients that I consult in this space rely on me for that. And I have examined all this reports and information, and I again want to thank Mike and Mr. Lyons over here for their hard work, making sure that we're very well educated on this. And I cannot ignore what we have heard from our city employee representatives with KPD and the fire department here today. And one more thing, as far as my career goes, and again, to working with human resources, the farther I get into it, the more unapologetically pro-employee I have become. I gotta balance that line, and I know the lawyers know that too with risk. But that being said, I've always been impressed since I've learned from Dr. Hatfield to split a division of powers here with having civil service. I think it's fundamental, absolutely wonderful practice, and then also having HR. I don't think in the private sector employees have any near chance of these benefits for their protection. So I applaud the city of Knoxville. I'm continually impressed with everything I learned about how personnel matters are handled here. And I think there's plenty of room for both. And to me, I want to echo what's best for the city employees, and it is just my professional opinion that having some of these EEO functions streamlined for them to go to a one-stop place for portions of this, like we mentioned, that is in the best interest of the city employees. And if anyone does have any further questions for me after the meeting, I'm happy to provide my rationale for my reasoning with this. But that is really my final statement that I want to make regarding this. And I understand we got to go through the process and rule change, whatever we need to do to put votes on it. But maybe this is something that the Civil Service Merit Board can actively work on the next few months. Again, listening to what the city employees here are telling us of how they would like to have this designed, because I am understanding that it's within our power to do so. That's a lot.
Thank you. Does and I'll say before, and we don't have a vote here, this is just the informative, so I want to thank Mr. Winchester for doing the work we asked him to do, and just say, I wanted to be clear, we absolutely are bound by the charter. I absolutely understand that. It's over any ordinance. It's certainly over any rules, which are third in line on these matters. It's just as I want to make sure that we know what we are responding to and when the appropriate time to respond and how, just taking that all into context. And right now, there doesn't seem to be anything before us that's actionable. There might be at some point, but But this has been good to get the background that we have and the perspectives that we do have. It's just, that this is not the first time, I will say. It does put the board in a difficult place when we're kind of like making our own minds up about what the charter says, which I don't really think is optimal. Then it puts everybody in confusing space when we have our attorney and then, advising us, and then we have a city attorney and you have the interpretation of the charter. It's all a lot to sort through to try to get right and honor the meaning of the charter. So anyway, I've just heard a lot and appreciate all the information that we have. So again, there's no vote here. So we will consider this a discussion well had and go on to item 9. Now, normally by Robert's rules, we'd have the motions and seconds and then here, but I think given the context is a little different for everything here today, so I'd rather maybe go in a different order here first from the people who have asked to speak. And those are, again, Larry McAfee. Are you still with us, Mr. McAfee?
I'm still here, but I don't have to speak this time. Thank you.
Okay. Did you say you did not want to speak? Do not. Okay, thank you. And Mr. Booker from the police. And then we also have Mr. King and Ms. Cook also signed up to speak.
I'll wait my time. Thank you.
Okay. Steve, you're next. Would you, Mr. King, would you like to address this?
What item is this?
This is item 9. This is the item on the request for board approval of a General Government Employees Association provider written summary report.
Okay, thank you. My name's Steve King. I work in engineering and I'm currently the president of the City Employees Association. I guess I'm not sure that Mr. Winchester got to where he wanted to be, but I have a couple of general questions that I'd like to ask before I address the item that I requested be put on. Is that okay, Mr. Blount?
Well, generally, that would be in the section that if it's the will of the board, I think we can make that.
Well, I think it's clear, but just in my own mind, I want to make sure. Mr. Winchester, I understood that from your comments that you it's not your opinion that the charter gives the mayor authority for EEO Title VII. That's rested within the mayor board.
I can't give you an opinion, I can give the board an opinion. So if you want to ask your questions, you can, but I really can't give you an opinion.
Okay.
The board's already told me they heard enough from me, so I'm not going to.
Well, I think I was hearing you get there, but maybe I just wanted to make sure. And then my other question, which I guess you would have the same answer, would be that if that's the case, that the charter does assign that responsibility to the Civil Service Merit Board for Title VII, that no action by the mayor or by city council could change what the charter says. But that gets to the point why the Employees Association is requesting that Mr. Winchester make a report of his findings that we would like to see in a written format. We would like it to be provided to the mayor and city council. And that's what I was requesting in that item.
Okay, thank you. And
Do you have questions regarding that?
let's say we do have, Ms. Cook, did you want to speak too?
Sure.
Yeah.
Go ahead.
She asked her question first.
Wait, is this a question for Mr. King?
It is related to the General Government Employees Association, so. And my question too, it's my understanding, so Mike, you are the attorney for the civil servant.
This
Merit
board.
So are city employees able to go to you to provide?
No, they never have, and I'm not their attorney, I'm your attorney. That's why I can't give you an opinion.
Okay. So I just wanted to clarify that point too. If the General Government Employees Association is seeking, additional report to provide to the mayor. I'm not sure if that is something that is Mike's ability to do.
Only you could authorize me to do anything like that, provide any kind of report, which I've already done, and you said you've heard enough from me, so only you could authorize something like that.
I just had some questions, I guess.
Right. And again, we're not to our discussion point yet, so that was a question, I believe.
Yes.
Anyway, from this part of the presentation, so we want to, do you have any other
No,
questions?
I just was curious, does the General Government Employees Association, do you have an employee lawyer, on retainer for these kind of purposes?
No.
That's all. So, thank you.
Okay. Thank you. Ms. Cook?
I have, because I'm gonna be like everybody else. I'm going to my corner. You do.
That's a good point.
It's a good corner.
Yeah.
Dr. Lyons, I did.
I'm sorry, excuse me just a moment. We have a request for a handout that
Yeah.
we generally have done, necessitate those being done prior to the meeting. However, I'm willing to entertain an exception to that if it's but okay.
You can vote to waive.
Waive that, yeah.
You're in control of your agenda.
Right. So, do I have a motion to waive our,
Motion to waive.
okay? Okay, all those in favor?
Aye.
Okay, so we can have, I just needed to go through that
Thank
to
you.
keep it
I
up.
appreciate it. What I just brought for the board members to have at hand, and certainly it's way too much for discussion today. I think I have 5 minutes. So I brought parts of the City of Knoxville's ADA self-evaluation and transition plan that was completed in December 2019, accepted and approved by the Mayor's Council on Disability Issues in December 2019, and accepted by City Council 2019. And I have highlighted for you just a few salient points through it that I will share. The city does not have to take any action that will result in a fundamental alteration in the nature of a program activity, create hazardous condition for other people, or result in undue financial or administrative burden. This determination can only be made by the city's law department in consultation with the ADA coordinator and/or an authorized designee of the city, such as the mayor or mayor's designee. Next page. City has appointed Stephanie Brewer Cook as ADA coordinator. Below is a list of qualifications for ADA coordinators that are recommended by the U.S. Department of Justice. You have those. You also have examples of the types of work that is performed by the city's ADA coordinator. These are all publicly available documents. They're in my position description on the city's intranet. Page 13 says, any complaint from an employee alleging discrimination by the city on the basis of a disability should follow the procedures established in Article 17 of the Civil Service Merit Board Rules. Page 14, Section 3.14, Title 1. Reasonable accommodation request process plays an important role in ensuring that the city does not discriminate based on disability. Applicant accommodation request form is available on the city's employment application website. Any applicant requiring special assistance to prepare an applicant accommodation request form may contact Civil Service or the ADA coordinator for assistance. Copies of all correspondence shall be forwarded to the ADA coordinator. If the applicant received a negative response from the executive secretary, the applicant may appeal the decision to the Reasonable Accommodation Committee. The city's Reasonable Accommodation Committee consists of the Americans with Disabilities Act coordinator, director of finance, director of laws, designee, and the Civil Service Merit Board executive secretary. Page 15. To request a reasonable accommodation in the performance of essential functions of a job, city employees can reach out in various ways. Upon notification, the supervisor shall provide the employee with an employee accommodation request form or complete it for the employee if needed, and shall send the completed form to the ADA coordinator. The supervisor, in cooperation with his or her director or department head and the ADA coordinator, shall then engage in an informal process with the employee to clarify what the employee needs and to identify the appropriate reasonable accommodation. Page 16. A director or department head has the authority to approve reasonable accommodation requests. Copies of all correspondence are forwarded to the ADA coordinator. The city will periodically review its Title I reasonable accommodation request procedure and policy and request from time to time changes to make sure that the materials are clear, posted widely on the internet, website, and publicized in common areas throughout the city for both employees and community members to see. Page 17. The ADA coordinator website contains, among other resources, an ADA complaint form. The ADA complaint form provides an avenue to effectively report issues to the city's ADA coordinator and to enable city staff to improve accessibility to meet ADA expectations. Page 18. 3.1.7 retaliation or coercion policy. Individuals who exercise their rights under the ADA or assist others in exercising their rights are protected from retaliation, intimidation, coercion, all of that good stuff. This prohibition against retaliation or coercion applies broadly to any individual or entity that seeks to prevent an individual from exercising their rights or to retaliate against individuals for having exercised their rights. I simply wanted to point that out to you, that in none of the discussions that I've heard, seen online, or in the reports, none of them say the importance of the ADA and the ADA coordinator's position. I've been here for 25 years. I have been the ADA coordinator since 2012, I think, and I got my national ADA certification in 1 year later, 2013. The next page that I'm sharing with you, also nothing in this report discusses disability services. Disability services includes everything that isn't fully ADA compliance. It's not employee accommodations. It's not constituent complaints. It's where I sit on statewide and countywide and some regional boards to understand what's the current most important issues on the radar of the ADA or disability community may be. And honestly, you may tell that I'm a little bit emotional about this. This is offensive to me. The summary and the recommendations is offensive to me. City employees know I've got their back. I've helped accommodate employees where departments would not. I've had to educate departmental heads. You should never say that out loud because that's discriminatory language. You know, there's a lot of education. Yeah, we can continue to educate, we can continue to learn, but I'm here as a resource. In the recommendations, if anybody has bothered to print and try to read through the 900 pages of appendices, you will see in there, my job is recommended, break it off, put employee accommodations in HR, put facilities and sidewalks and right-of-way work in engineering. Fine. What happens to the work of disability services? That's all I want to ask. I need you guys to reconsider this because I feel like it's important enough that I reach out to the feds and make sure that they are fully aware of what's going on, that this process, if approved and recommended going forward, totally takes away any ability I have to do my job.
What would you like it to do?
I'm sorry?
What would you like the change to be, or no change, or how would you like
The ADA employment accommodation process ain't broke. It doesn't need fixing.
And just to say thank you, I have an ADA disability. Most people don't know that, so, I mean, I appreciate
25% of the population does. Yep, and that doesn't include seniors. So when we combine the two, that's 50% potentially of our employees. You know, and I can tell you that when I am brought to the table, involved and included, we've had 2 EEOC complaints. Both of them were dismissed. We've had our more recent one, wasn't dismissed, the city had to settle. 3, because I was excluded from the process. So that's all I wanted to share today. Thank you for listening.
Thank you very much for sharing. Okay, so do we have a motion on item 9?
And Mr. Chair, if I may, this may be
Yes.
out of order, so feel free to tell me if it is. I'm happy
Would
to
the board like to
respond.
hear from Mr. Lyon? Let's go through at this point.
Yes.
Yes, okay, thank
We
you.
request you stand at the drumming corner.
I'm happy to. I was gonna assume my position in the hot seat, if that's all right.
Go to the drumming corner.
If I'm over here, I can actually see everybody in the room instead of in the corner where I'm not really facing the board members. I'll be brief. Just in response to that, that's a little surprising to hear. I hate that any employee would find any recommendation in this report to be offensive. I'm confused by that statement, particularly in light of the MTAS benchmark survey results, which uniformly conclude that ADA practices are handled via HR. And in fact, in the recommendations specific to ADA that were included in the report and that do include disability services, it's actually prioritizing ADA concerns such that the ADA coordinator, which position is not proposed to be changed, would still serve in that coordinator function instead of having to be the one and only person that the city has, as you just heard from Ms. Cook, to investigate all things that may be allegedly ADA discriminatory or sidewalk repairs or transition plans, as she's citing from. It's simply too much, which other governmental entities similarly sized recognize, to have one person who performs those functions. And I recognize the statement, if it ain't broke, don't fix it, but I think, the fact that the ADA coordinator position is currently located in the Housing and Neighborhoods Department, that alone is enough to demonstrate that it's broken and it's not effectively placed where it needs to be. So again, I just would encourage you all, as you're digesting what admittedly is a very long report for very good reasons, to consider what the benchmark survey results have shown. And Mr. Chair, I'm happy to, if you would like, I can briefly opine on one other charter issue if you'd like to hear, or I'm happy to leave it at that. It's totally up to the board what you
I'd
all
like
want.
to have a chance to respond to you before you move to your next section.
You,
Oh, I'm sorry, I'm not the chair.
That works, that's appropriate.
okay. Mr. Lane, you were the city's ADA attorney when we changed Admin Rule 12, titled Miscellaneous, to create Admin Rule 15 that discusses the process for ADA compliance. I have not been involved in this conversation. In fact, up to about 3 months ago, I was trying to look at ways to shift some of my responsibilities to another department, to share my part-time employee with another department to try to work on some of this. Then the report came out. So I've been shoved aside, put in the corner, left in the dark. I had no idea this summary study was going on, that the summary was coming. Okay, so I've had a lot of catch up to do. I don't know who else read through the 900 pages of appendices, and I may certainly have read it differently than those that drafted it. But I feel like it is important enough that we discuss in deep detail, doesn't have to be here, exactly how we process ADA issues and how disability services work. I agree, it does not belong in the Housing and Neighborhood Development Department. There's a history there I won't go into, there's a reason why that was there, and that reason is now moved. But frankly, disability services, I believe, should stand alone. And it should probably be under the arm of the mayor's office because it is so impactful. Every city policy, procedure, facility, and employment activity could be impacted by the ADA. So that, I'm happy to discuss further details of how we do this. But I can tell you that the employment accommodation, if a department will involve me, I don't have the power to make them, but if they do involve me, I guarantee you the outcome for the employee and the city is always better than to exclude me from experience.
Thank you.
Thank you.
Anybody have any other, did you want to hear Mr. Lyons' other comment on the charter discussion, assuming it's brief, or is the will of the board to Go ahead.
I'd like to hear what he had to say. I mean, that's their own opinion. I thought he had, like I say, but I also want to hear Mr. I'm sorry, my brain doesn't Devin. What you have to say. I mean, I do think we need get all the information on the table.
Let us, let me back up and say, we're getting a little out of whack here. We have an item, I think I had asked them, is there any motion on item 8, item 9, so maybe, unless, I don't think this discussion is relevant to item 9. So let's go ahead and resolve that, and then we can go into the other business briefly if need be. So is there anybody who'd like to make a motion on item 9?
I'd like to hear Mr. Winchester's opinion on item 9.
Well,
I don't have an opinion. I think that's up for y'all to decide.
okay. Not hearing any motion, item 9 dies for lack of a motion. Okay, so we're now on to other business, and if there was some request to hear, I will answer briefly, if that's okay. We put that burden on Mr. Winchester, so we'll do the same to you, but any brief response you would have to the charter question.
Absolutely, and really it's not a substantive charter discussion. I'm sure you're all probably relieved to hear that. I've already spoken my piece on that. Some of you may have actually heard it repeatedly from the city council workshop, Mr. Dukes. But I just wanted to emphasize the point that I believe Dr. Lyons mentioned previously, that there is not an action item for the board. And I think any discussion of the charter interpretation that comes before the board, as observed, is premature and misplaced. There is, while certainly Mr. Winchester and I may disagree on the interpretation of certain key charter provisions, I think that disagreement is moot when you have a city law department and law director who agrees with the conclusions of the EEO report, and when those conclusions of the EEO report themselves are bolstered from a historical standpoint from the city law department at that time, as well as the drafters of Article 10 of the charter. This is a matter that, should the city pursue, will go to city council, and as Dr. Lyons noted, that is where that discussion can occur. But I wanted to emphasize that in hearing some of the discussion summarizing the report, and I disagree with much of that, but I wanted to make sure that the board understands that within this report, I have made no recommendations relating to changing the city charter or relating to the powers and duties as set forth in 1003F that are clearly powers and duties of the Civil Service Bureau. That is not impacted, that is not addressed in any way in the EEO report. All that is recommended is that a clarifying ordinance primarily be considered, which would revise Chapter 15 of the code, not the charter, to effectuate these EEO functions as originally intended by the charter and in light of the reestablishment of the HR department. So again, I just wanted I stayed silent earlier, but I just want to emphasize to the board that any charter discussion is not the issue here. The board is not being, and no one is being asked to revise or change anything in the charter or any power and duty under the charter that is held by the Civil Service Bureau. That's all I have, Mr. Chair.
Thank you. And I'll just make one comment, just because I think occasionally it needs to be repeated. The Civil Service Merit Board and the powers of civil service are established in the charter, and they're going to be here unless the voters of the city of Knoxville, upon something being submitted to them, decide to change that. I personally would oppose that publicly. I think that would be a horrible mistake. But, so I think when occasionally people say, well, we got to worry that somebody's going to do away with civil service. That's nobody's intent, A, that I'm aware of, and B, even if it is their intent, this isn't the place to do it, or that would have to be something that was held publicly. So, I think civil service is here because it's in our fundamental founding equivalent of our Constitution. And, that's which you may, help to remind us of periodically. And nobody need worry that it's going to be diminished or eliminated or anything else. Certainly this board doesn't have that power, even if it for some reason wanted to do that. So I'll just make that little statement. If anybody else has any final concluding epilogues or anything they'd like to make to the meeting today, if not, I would entertain a motion to adjourn.
Motion to adjourn.
Second.
Motion and a second. All those in favor, please say aye. Always a popular one. Meeting adjourned. Thank you.